where the person who is challenging the election, of the president, alleges that the president was not duly elected in accordance with law. And the dispute resolution mechanism in that respect vests jurisdiction in the Supreme Court because of the high stakes nature of presidential elections. I know, in the case of Parliament, it is the High Court that has jurisdiction, and that is understandably so because of the fact that we have 275 constituencies. You don't expect that if there are disputes, with respect to an election in Boku or Pusga, the person must necessarily come to the Supreme Court in Accra, because the Supreme Court is just the Supreme Court in the capital of the country, and so a petition. I mean, the rules of court provide for a petition to the Supreme Court. Basically, that is an originating process that kickstarts the jurisdiction of the court. It kickstarts the dispute, and it is designed to give the Supreme Court an opportunity not only to look at the complaint or the plaint of the petitioner, the reasons why he thinks that the person declared as president by the returning officer of the presidential elections was not duly or validly elected as president. Of course, as I said, is an originating process that leads to a trial. And as in your intro, you pointed out the lessons that we learned from the 2012 petition, in which my learned and respected senior UPO2 was involved. Was that we went through a trial of 8 months. We held the country spellbound to television sets on a daily basis for 8 months, and so we learned a very difficult lesson from that, and that is how come that His Lordship Justice Yonu Kulendi was making reference to the new rules that have stipulated a time period, a shorter time period of 42 days for the petition to be heard. So from the time my learned friend, Mr. Kwebu, was just asking me whether or not the respondents have been served, I haven't been able to check that, but I think it's very important because, for time to begin to run, they have to be served, and personally too. I mean, of course, in the case of the Electoral Commission, because it's an independent constitutional institution, any principal officer of the commission can be served with a petition and can receive it. In the case of His Excellency the President, as the second respondent, he must be personally served. Definitely. You can't just go and leave it at Flagstaff House or his residence at Nima, and then expect that he will be duly served. So we have some work to do with respect to, and I hope that the panel in this case, will find during the case management, will find a more expeditious way of getting us, into a shorter period of resolution. In fact, I don't even want us to go 42 days. That is too long. The Kenyans did it in 2 weeks.
Sure. Let's see how that goes. Thank you for that. And pardon me, I think I made an omission. I didn't call you by the appropriate title, Doctor.
Oh no! Don't worry. You can just call me. You can just call me Dominic. I'm not fastidious with titles. Yes. Don't worry about that. Don't worry about that.
So let me come to you, Mr. Kwebu. Doc has broached the bit about the timelines and all. I want us to look at that into some detail. So when a petition is filed, what next? Take us through the procedure.
So I'll just take off from where Doc landed. So you see that the key thing is that these timelines will only begin to count upon service. So it tells you that if the parties and the court intend to insist on the times that have been allocated to them, we are coming to those details, it will mean that in practical terms, we'll go beyond 42 days. Yes, because as we sit now, since the president is not being served, the time doesn't start. So it means that if it takes 1 week, that's 7 days to serve the president, then it means that you have 42 plus 7. So it's possible that the judges, if they want to give us exactly 42, they may have to give up part of their time. They have 21 days. We are coming to that shortly.
Sure.
They have 21 days to render their verdict. So maybe they'll be thinking of, okay, giving back the time that we've lost in attempting to serve the parties. Now let's come. So the rules
But
say...
it shouldn't be difficult to serve the president, should it?
Oh, no, in practical terms, let me be frank with you. This morning when I was coming here, then it dawned on me that, look, moving forward, next time we're going to have an election, there should be a column where they will say that, okay, when you are nominating the candidates, there will be a column where you should provide his address, email address for service in the event of an election petition. So that when it comes, and then we amend the rules accordingly. So that when it comes to
electronic
then you just do it electronically, straight. So that we stop this rigmarole. You know, now they'll be chasing the president around. I can't imagine trying to get security clearance to go and serve him.
I know.
It's ridiculous. I just looked at it and said, no. Well, this petition is going to test the rules because we've already lost some days. I think today is from Wednesday. Today is Saturday. Yeah, so the rules will have to be amended. They will have to be, unless, as I said, the judges are willing to yield part of their 21 days.
Sure.
So
or
the
perhaps
rules
as part of the peace pact that is signed ahead of the elections, I mean, candidates should say, well, we won't, make it difficult for service in the event of this, because it's all part of the process.
Yeah,
like we said earlier, 8 months of, being in court, it's just too long.
Yes.
The country suffers. So as a show of goodwill and that you're ready to commit to the process, indicate, whilst you're indicating your address on the form, that you won't make it difficult for service. You know what I mean?
Okay, yeah, that's also an innovative way. Yeah, that's an innovative way. Okay, so it says that when they are served, each, that's the president and then the EC, each has 10 days to file an answer. 10 days. So at the end of the 10 days, the next stage is what we call pre-trial. Pre-trial, so that is to say before the trial. That's before the people enter the box, like what Dr. Baumia was in the box, you and I were not there. So before that one, the court would meet, so the parties, then they would go through the evidence. So part of the pre-trial, I think I don't want to use the legal terms. Let's just use ordinary English. As part of the pre-trial, they will look at the evidence that each party, that's those that are documentary, each party intends to adduce. So they will check. Okay, so Mr. Mama, have you and your lawyers served your documents on the respondents? And they will check everything. Yes, respondents. Have you also served? How many? So each one of them. In the there's a witness statements and those they are going to tender. How many exhibits do you have? They would mark the exhibits, give them numbers. Usually, petitioner would have A, B, C, D. Respondent 1, 2, 3, and so many other things. Okay, do you require a translator? Okay, maybe Mr. Mama wants to speak Gonja, so maybe they'll bring a Gonja translator or. I mean, so and so on and so forth. Yeah, that's just we know Mr. Mama speaks good English, but just sometimes for the fact he can decide that look, I want to speak Gonja, so bring me a Gonja translator, or those things. Just like the president can also say he wants to speak Twi, so a Twi translator, So they will do all those. So that's in the area of the pre-trial. They will also check: are there some people that have to be subpoenaed? Okay, are you bringing anybody from a public service, maybe some EC officers, not the EC, there's a chairperson. Maybe you want the director of elections to come. So they say, okay, you want to issue a subpoena. So in a nutshell, there are so many things. That's why it's called pre-trial before. Like the way in the studio here, before we start, you test the mic, you check everything. Yes,
go through the checklist.
Exactly. So then, after that, the next stage is the third major stage. So we've done answer, so service number 1, answer within 10 days. Then you do the pre-trial. So that's 3. Then the 4th stage, the trial is a plenary. That's the one the witnesses are going to enter the box. Will start. It says that it should start on the 15th day. So the 15th day, and they have 7 days. So if they start on the 15th day, they should finish on the 21st. So 7 days. That's where I put it to you, and all those the pink sheets and all that come in 7 days. They must finish. Then after that 7 days, so now we're on the 21st day. Then the judges have 21 days to retire, consider everything, and come back with their opinion. So 21 for them. Yeah, so that's how we account for the 42. But as we've already said, practically, it looks like there's going to be an overshot unless the judges yield part of their time, or even within the 7 days. But the way trials go and lawyers do cross-examination, it doesn't look like practically we should be expecting the lawyers to yield part of the 7 days. Yeah. It doesn't. Yeah. Where we may expect is maybe the 21 days that the judges have to give the opinion. They may be able to. That's when the sacrifice
is likely to happen.
Yeah, because in the old rules, it said they should give their decision within 15 days.
Right.
But this new rule say 21. So since they already used to the 15 days in the old rules, maybe
it shouldn't
they
be a
can.
Problem, sure.
So that we stay within the 42, because it looks like Ghanaians are very excited about the 42. So on our first attempt, we should do everything to see if we can do it within 42. But if it doesn't, Abner, you know it very well. We already have decisions that show that if you go beyond 42, it doesn't make the decision void. No, long ago. I think PPP, it's around 2001, 2002, thereabout. So about 18 years ago, we settled this question.
Yeah.
If we say finish within a certain number of days and the judges are not able to finish, it doesn't affect.
Exactly. I was going to go with that just for purposes of settling any misconceptions out in the public, if there is any such misconception. But you talked about witnesses. The use or the resort to witnesses is not necessarily cast in stone, as in it must happen. It is where the justices or the court deems it necessary to call in witness, because as it is, you're presenting the petition with evidence attached. And so really and truly, it could be determined on the basis of those evidence presented. Is that not the case?
Great, you're right. On paper, in theory, perfect. But I see this time, I'm sure Doc will even come in and explain more. The NDC have done a technical thing. They've not attached all the pin sheets. So it means that they will need witnesses to come and tender. Since Doc was in this situation, maybe we can add more flesh to it. So once they've done that, it means that on the facts of this case,
we took the view that you don't file your writ of summons and statement of claim with all your evidence. So the full complement of the evidence will come along, at the point where the trial takes place. And for instance, as Martin was saying, we have the pre-trial period. Okay, that is basically a case management, mechanism. And so at that stage, it should be possible, for us to indicate to the court, okay, the kind of evidence we want to call, the number of witnesses, and so on. And it is at that stage that, we'll prepare the witnesses and then the evidence that we will be, submitting. So unlike the strategy that my learned and respected senior and co used in 2012, where they brought, truckloads of their evidence together with the petition, we have decided, to adopt a different approach this time.
Right, but the learning in there is that even though those were upfront, we still had witnesses called. So then obviously, in this case, witnesses would be called.
Yes.
Very well. Now, Mr. Aiko to
His Excellency.
His Excellency. Exactly, His Excellency. The rules provide that a respondent in answering the petition would obviously state facts and everything in there, but also if they have a preliminary objection, they should state it in there. I would want us to be, to educate listeners and viewers what that would imply for the process going forward. If there should be legal objection put in there, how would that change the course of the procedure? Would that also be factored into the 42 days or what? Because trial would not start until that preliminary legal objection is dealt with.
Okay.
And in fact, what is a preliminary legal objection, perhaps? That is to start with.
Let us put it this way. The judges are in control of the trial. That's a basic thing. If they decide to give you latitude to do whatever you want to do, that is their discretion. If they say, no, we have read it, we are satisfied that this is what we ought to do, these questions you're asking are unnecessary, we don't want, they can order the witness not even to answer. What you're asking are unnecessary, go this route and that. So if they take control of the trial, things will move faster. That's number one. Number two, you want to raise a prior objection to say that something is not proper. In other words, that maybe a party whose name has been put there ought not to have been there. It ought to be struck out, or the application is not properly before the court. That is a prior objection. That ought to be dealt with first. So you don't have to hide the information that you intend to take a prior objection only to come and spring a surprise on everybody on the day of the trial that, my Lord, I have a prior objection. So what they are telling you is that give enough notice in your answer straight away that you have a few issues that you want to deal with. But I want to add on a few of these things that they have said. Basically, I agree with them. But I say what the rules seem to say is that in order to fast track some of these things, include even electronic service, just to fast track some of these things. And then the provision that the judges must sit Saturdays, Sundays, public holidays, and all that. The last time, I think it was impressed upon them to do that, but they said no. They couldn't do that.
But we have not to it. Yeah. And they've now given a new decision last year, December, that the CJ, they have the right to sit Saturdays. They don't need a president's warrant. So they are back.
Sure. What I'm trying to say is that if only we could add that aspect, that can also help us. That, look, let's work. It's just a 42-day sacrifice. We finish and then, because imagine what investors will be going through. Somebody wants to come and do business and then he's not sure.
The uncertainty.
The uncertainty surrounding all that. So I will urge their lordships to try and see if they can work with these public holidays and the weekends and the rest so we can get this thing done quickly.
Right. Now, you were part of the NPP team in respect of the 2012 election petition, I want to believe. If not necessarily involved in it,
exactly.
but you followed closely. To an extent, you had to represent some people in court in respect of some contempt matters. We'll be coming to that. But what would you say, or do you observe any similarities or differences between the 2012 election petition as filed and the current one? Do you see any difference in terms of substance, not necessarily the form?
Well, you see, the point of this petition, that is, if you look at the lead up to the filing of the petition and what is contained, it's a little problematic because the idea that was fed out to the public was that, look, somebody has done something wrong. We have won the election, both presidential, parliamentary, and all that. But if you read it, you see that there's a clear request for a rerun, which is based upon the fact that then constitutionally, nobody crossed the 50+1.
Sure.
So that is a different ball game altogether.
Right.
Compared with what we were hearing before the petition was filed. That is the way I see that. It's a substantive relief. It is not like if you find that people voted without biometric verification, they order a rerun. If you see that these things were not properly done, then cancel. But this is a substantive relief saying that, in our view, nobody crossed the 50+1. So that, in my view, is the crux of the entire matter. Where is the evidence to support that view? In our case, we are saying we won. And that these things led to, a presiding officer refusing to sign. People went and voted without biometric verification, blah, blah, blah. So we gave specific instances, that to us made us to lose. In their case, they are saying no, nobody crossed 50+1. So they have a bigger responsibility, in my view, to show that, and they need to present the evidence. I would not give any advice at this time.
I'm sure it will be the first time that the Supreme Court is committing an ambassador for contempt.
So that is where the responsibility lies. And that's the difference I see. They have also gone on to ask for cancellation of the instruments, you know, and the presidential, you know, and all that, you know. For me, the important thing is what I've spoken about. Once that didn't happen, all the rest will just follow. You know, so
very well.
Let's see what happens, because if you look at the samples of the petition, what is said is you should be bold to say that I won the election. This person did not win the election. You know, but their style is different, and like you're saying,
I don't think it's that cut and dry. That in pleading and challenging an election petition, you must necessarily say that candidate A, who was declared the winner of the election, did not win, and that candidate B ought to be declared the winner. That is a possible view of the universe within the context of the Constitution, that you can ask for those reliefs. But it is not also entirely out of place to ask that the actions of a public officer, the returning officer for the presidential election, violated the Constitution.
Sure. But I think it's actually what His Excellency...
No, I'll be coming, and ought to be declared null and void and of no effect. It does not also prevent you from saying that in terms of what I call the mathematics of Article 63, Clause 3, which provides that a person is declared a winner of the election if they obtain more than 50% of the valid votes cast at the election. Now, what that means is that there must be clear-cut evidence of the fact that a person obtained more than 50% of the vote. All right? And I think that, my reading of Article 63, Clause 3 is that there has to be mathematical exactitude with respect to how many votes were obtained in percentage terms beyond 50%. There has to be mathematical exactitude. It cannot be the case that we are basing it on an estimate of the extent to which the person went beyond 50%.
Right.
That cannot be the case.
Sure.
Because you see, if that were the case, it should be possible that if tomorrow my learned friend Mr. Kwebu here is appointed electoral commissioner, he's the chairperson of the Electoral Commission, he can call the election in favor of presidential candidate, His Excellency Ayikwe Otu, and say, oh, in my estimation, the presidential candidate Ayikwe Otu, got 52%. And then subsequently, when challenged, may revise the figures downwards to say 9%. Has the presidential candidate won the election? He hasn't. So we need not only the evidence of how much over the top in terms of the 50% you went to. Then also, Malene Senior spoke about the evidence of infractions and so on. Okay. Of course, we as you said in your intro, we are not going into the merits.
Definitely not.
We are not also going into the evidence. All right.
But you say you have them.
Yes,
you definitely make it available.
And he made a very fantastic point with respect to the differences between the 2012 petition and this one. But I would say this, generally, that our petition as it is now, especially if you look at it, it dwells more in many paragraphs on the declaration.
And as he said, yes, we can't go into details, but
and as he said, our request to the court is that the declaration be declared unconstitutional and the president-elect instrument be set aside. That's all that I would say. However, in subsequent paragraphs, from I think paragraph 31 onwards, we put, in the petition, issues of vote padding, all right, and irregularities that occurred in the course of the election. Of course, we, unlike in 2012, where, as he said, they were asking that the votes across over 11,000 constituencies be annulled on the basis
polling stations.
Polling stations, be annulled on the basis of, let's say, presiding officers not signing, voting without biometric verification, and so on and so forth. All right. We haven't detailed all those things, but that doesn't mean we don't have evidence of those things occurring.
But that's fine, Doc.
Okay.
I think the thrust of His Excellency's question was that
if we have not pleaded it, can we lead evidence?
No. It's not even about that, the pleading per se. He's saying that he sees a stark difference between the position the NDC or the petitioner had before the petition was filed.
Yes.
And what is contained in the petition. Because, I mean, post the declaration of results, I think the initial agitation by the NDC and the petitioner, indeed, was that the presidential candidate, their presidential candidate, had won.
Yes.
And I think, in fact, it was on the basis of that that they asked, the leaders of the party, asked people to go onto the streets because their mandate was being stolen.
Yes.
And in fact, they were asking the EC to do the right thing by overturning or declaring their candidate the winner.
Yes.
So what is striking is that when you have such a position before the petition is filed, and then you see that that is conspicuously missing from the reliefs, then it would seem as though you have abandoned that, and now you're saying, well, there was no clear winner, and so let's have a rerun. And so I think it's that difference in position we want to understand. And that is what he's commenting on. Am I correct?
Yes,
I believe that's what I got from.
Yes.
Yes. And I mean, that is a true reflection of what happened. But the question is whether in challenging an election, of the president, your public utterances must necessarily reflect in your petition.
The reason why I find that question important is because
we can go back.
People have lost their lives.
Yes.
People have been injured because they went onto the streets to protest.
Who has lost his life for going onto the street?
But the NDC, for instance, puts the figure at 8. Eight persons
but
have
you see,
died.
Those 8 persons specifically protested long before John Mahama came out, to make that statement.
But the John Mahama statement was on the 10th.
This is very important. The Ghanaian people are listening to us and watching us. In Techiman South, the happenings there were not as a result of, His Excellency John Mahama calling out people to the streets. It was as a result of events that ensued at the polling station, at the collation center. All right. The trigger-happy gunmen who went and shot at the protesters, were people who, went there at the request of the law enforcement authorities, all right, and instead of, keeping the peace, they went and shot people, all right. So it is not, I don't think that we can lay the blame at the doorsteps of the NDC leadership that because of their call to demonstrate, lives were lost because we said, the mandate is being stolen from us. All right. Now,
on hindsight, would you say that call or that statement was perhaps a little bit, I'm using the word very advisedly, like unguided?
No, it wasn't.
You still maintain that it was a good position.
It wasn't
you
unguided.
You that you had won, but in your petition...
Pardon?
It says, before the petition is filed, you declare categorically that you've won, the mandate is being stolen.
Yes.
And then the petition is eventually filed, and you don't have any...
There is evidence of the stealing of the mandate. All right? For instance, my famous example is from the Eastern region, where there is a video of the regional elections officer announcing the results of the presidential election, all right, for the region, having collated the figures for all the constituencies in the Eastern region. The figures that she announced happen to be the same as those contained in the pink sheets that we had, and that which the MPP also had. But what was sent to the Electoral Commission had a different figure and had, given His Excellency Nana Addo Dankwa Akufo-Addo more votes than she had announced. Now, these are, and across the country, you see, we saw a pattern of that happening. For instance, from my own region, okay, the Upper East region, results were transmitted to Accra that were different from those that had been collated at the Regional Collation Center. It took the vigilance of our regional secretary to say that no, what you have sent to Accra is different from what was collated here and announced. And the regional election officer conceded and said it has to be corrected. So these are all. And
it was done.
Yes, it was done. Okay. These are the instances where which show to the party leadership that there was a pattern of trying to steal the mandate in favor of His Excellency Nana Addo Dankwa Akufo-Addo.
Well.
And so if we made those statements, they were not made based upon, rumor. They were not made based upon just a desire to call people to arms and so on. And I must say that, I'm sure all of us here will agree that Mr. Mahama is a peace-loving person and would not call people to the streets, to get shot at so he become president. No, he won't do that. Very well. Yes.
That's fine. But Mr. Kwebu, your thoughts on this? Because, we've had, I don't know if you were part of the conversation the last time we were here about these protests and the calls and all of that. What do you make of that difference in position? Before that, there was a second statement, a categorical one, that we had won. I know there's a political side to this whole thing,
exactly.
But then there's also the judicial. But again, we are looking at, trying to see how our democratic processes and everything could be, fashioned out in a way that would inure to the benefit of everybody, as much as possible, not to lead to the loss of lives or injuries and everything like that. So what do you make of that position? And again, we're using this as, trying to get people to understand the processes as they occur.
Okay. So, number one, the first statement, so I stand to be corrected. I don't seem to have followed that one particularly. Where I particularly remember is where he said, Mr. Mahama said he would only accept the results when the EC does an audit. That's the one. So the first one, sometimes, we are basically not following the news all the time. We are lawyers. That's where we earn a living. The first one.
I'm sure we can get a tape. If we have that tape where such declarations or statements were made, it would be useful to play it for the purpose of this conversation. So that, yes, as they look for it. But the key thing is that even when somebody's made that statement, the question is that, so immediately after, did we have demonstrations based on that statement? You see, so as far as I remember, the demonstrations came after the CI was issued and all that. So where I'm basically going to then land is that the man makes a statement. If that one didn't lead to the demonstrations, then maybe not much. I stand to be corrected. In matters like this, it depends on what I've heard or what I've seen. But the key thing is that, look, we all say it in certain times. It may not be right, but we should play emphasis on what we do. They say actions speak louder than words. Sure. So the key thing I stand to be corrected on is that if on the 10th he said I've won, but they did not embark on any demonstrations based upon that one, and no lives were lost based on that one, but it was subsequent, even after the CI 135, the one that declared Mr. Akufo-Addo as winner, it was after that subsequent there were demonstrations. Then maybe we can just let the first one pass.
Let me interject here. Mr. Martin Kwebu is saying that basically he practices law and he may not have much time for politics. So,
even when you practice politics, not everything you can do
within the news cycle.
The news cycle.
That's why I'm saying that I'm prepared to grant him that.
Yes.
But we are all in this country, and when people are called upon to go and protect their votes. What is the meaning of that? Go and protect your vote. You understand? Then go out onto the streets, and what all this call about, go to court. So we won't go to any court. We don't even trust what is happening, and we won't go down.
Now they'll go to court at their own time.
But
Exactly. No.
with all due respect,
I want to
my
make
senior.
this point that
Just a minute, let him land out. Then
we
we'll come back to
cannot
you.
say that it had nothing to do, its declarations had nothing to do with the demonstrations, because even after filing the demonstrations, it was reported, he said that the protest will continue.
After filing the petition.
Yes, even after filing the petition, then the protest must continue. So
But the word protest there, I'm not sure you're saying that the outward demonstration. People are saying there's a difference between protest and going out to demonstrate.
But
You can
when people,
demonstrate
hold
on
on.
paper, news conferences and the rest. So
You
let's
see,
see, that one is slippery. It's slippery.
No, please, at this stage, if you ask your demonstrators led by a former...
Your supporters.
Supporters, sorry. Led by a former women organizer or so, to go to the EC to demand that she should change the results. Consistently, we saw it on television playing out. People fighting with the police, throwing stones, destroying.
Disassociated. Remember, there was a comment about saying that you said after he filed, he said they should continue the protest. And I said it doesn't necessarily mean street demonstrations. That's the only one. So I don't want you to be saying that.
Oh, so you agree that there were street demonstrations?
Yes.
Oh, yes.
there were.
And what we say that,
Certainly.
what were the causative factors? What led
But
to
those
it?
are the things we are telling you, that the first part was go and protect your votes.
Yes.
Well, these things.
These things that happen with shooting and the rest, what was the need for it? People claiming that they are protecting votes because things were happening. They are being cheated out of something and all that. I'm telling you, that is the clear difference. After the petition was filed, and when we read it, we saw that what they have done up to that stage was not on. To me, just apologize that, we erred.
Very well.
No,
And then let's move on.
I don't think so.
But if you still insist that
I don't think so. Your
all the
Excellency,
things
with all
you
due
said
respect.
proud to, let us play the tape.
We will try.
Where somebody
we'll
says,
try that.
we have won
Production team definitely get
140
that.
seats already.
No, it was
We have
TV3
won
that declared
both
149
presidential-
in favor of your party. It was TV3. It turned out to not to be true. It was
Right
TV
We will settle it right here. Doc,
I
yes,
mean,
please.
Let's move on.
Your Excellency, you see, sometimes when the MPP is in government, they become very sanctimonious. They preach, to those of us who are not in government about how to behave ourselves and so on. But Senior was there in 2012. What happened at Obrasport? What happened at Obrasport? You basically called people to arms. Then you told them, Sir John, the late Sir John, may his soul rest in peace, called the supporters to wear white and go out and celebrate the victory of Nana Addo Dankwa Akufo-Addo. Didn't that happen in this country? No, please.
Okay, carry on.
But you see the consistency.
You let him finish.
But because you are
Let
talking
him
about
finish.
consistent behavior as against inconsistent behavior. The consistency in the actions of Nana Addo Dankwa Akufo-Addo and the MPP is that they went to court and said, we won. Nullify all these votes and declare Nana Addo Dankwa Akufo-Addo the president of the republic. But in terms of the actions on the street, they did not differ from what happened now. Except that, and I want to say this, because I was inside government. I was a member of the police council, sitting there on behalf of the Attorney General of the Republic with the late Vice President, Emisata. We never deployed the police to shoot at anybody. That's the difference. That is the difference. If your government didn't order the police to go to Techiman South and do what they did, we would not be here talking about losing lives as a result of a statement being made by politicians. Because your colleagues, senior colleagues in government, in your party, Sir John, Yabo Abinga Samoa and Co. at Obrasport made worse incendiary statements. They called your people to go onto the street, but we didn't go out to shoot them.
You see, let us draw a distinction.
We respected their right to demonstrate as enunciated in Chapter 5 of
I
the
think you have
Constitution.
made that point.
We'll
Thank
need
you.
to,
The
we'll need to
important
bring
thing
some
is that
finality to this by listening to the tape, but I will give His Excellency.
you see, the important thing is
on.
that was the first time, 2012, that people were having difficulty with elections and wanting to demonstrate and decide whether to go to court or not. After 2012, we've learned our lessons. So why that path again? Knowing that the best way to handle the matter constitutionally is just go to Supreme Court.
Oh, but
Why go back to those things and to get all
the
these
tape is
results?
ready. If it
Okay,
is,
yeah,
please,
we can watch
let's
the
have
tape.
it
We can
played
watch the
and let's see if it helps resolve the issue at hand.
Accept the outcome of the election as declared by the Electoral Commission Chairperson, Mrs. Jane Menson. These results are flawed and discredited. When it comes to the parliamentary election, the NDC won a working majority of 140 seats.
Okay, so that has to do with the parliamentary. That
Candidate said so.
the NDC had won 140,
Yes.
a categorical
And then the
statement.
other one where it
Yes.
says
And
we
then-
want both
In fact, we
presidential
won
and
more than
parliamentary.
we won more than 140 seats. Abina, we won more than 140. All right.
These are the things that led to what we are saying.
Currently, 137 seats have been certified for the NDC. Techiman Saf is outstanding. And Marlene Senior will agree with me that in Techiman Saf, okay, the public elections instrument was not followed. There was no collation and a proper declaration was not done.
So that is going to be contested, I suppose, then?
Yes, we have filed a petition.
Okay.
That is
the
where
High Court.
I was coming
Yes.
to. You know that once the results are declared, the only way to
No,
talk about it.
Set them aside.
if they are lawfully
It's to go.
declared, if they are lawfully
no, I'm
declared,
saying is to go to court.
but if they are
so
law-
you've done the proper thing by going to court.
Please let
Senior, can I
Doc
ask you a
make a
question?
statement, yeah.
Are you saying that as an administrative authority, the Electoral Commission, okay, the commission properly constituted, cannot call a returning officer to order that the returning officer should follow the law and properly collate and declare the
That is
results?
before
You
it's
see,
So
declared.
then he
Remember-
declares
Declaration.
the results illegally, contrary to the regulations. Then you tell us, go to court.
There's nothing you can do about it.
No, there's
The
something.
After
EC sits
declaration,
in Accra.
Doc, let me just
And
get it
these
clear.
informations will be sent to Accra.
Yes.
At the end of which the results will be gazetted. Once the results have been gazetted, everything is over. Your duty is to go to court to challenge it.
And
file an election,
we've gone to court.
which you have done now.
Yes.
Was it necessary for what happened?
Well,
So we should not protest. Senior, we're not involved in the MPP and IGP litigation in the Supreme Court on the right to demonstrate.
But we settled that
Your
long
party,
ago.
your party,
very well. So, demonstration or protest within the confines of the law.
the law.
Yeah.
No problem.
No problem.
Yes.
But the minute
Yes.
you begin to go contrary
Of
to
course,
that,
yeah.
that is where the problem
That is a
comes
concern
in.
to all of us.
Exactly, and
Yeah.
that is what we need to be looking at.
Okay.
But let's look at this. Aside, this petition that has been filed, we do hear the NPP chairman indicate that the NPP will also prove that John Dramani Mahama got less than the votes he was credited with. Should we expect a cross-petition of sorts from the NPP, His Excellency?
In fact, honestly, I do not have a view on that one. He is the chairman. Let me say that.
He's actually not the chairman. He's
the
a campaign
manager.
manager.
Yes, former
So
chairman. Though,
what
yeah.
he may know, I may not know. So I do not have any view on that at this stage. That's what I like to say.
Very well. Mr. Kwebu, if that should happen, what would that entail? What would that mean if there's a cross petition? Obviously, throwing the 42 days timeline out of the window.
They would, as
Or
you
they'll
see,
still fit it in.
Exactly. That should be right, because looking at it, or they simply, even without making it a cross petition, in the answer they can still seek to prove that Mr. Mahama didn't get that number. Yes, because it appears the way we are excited about the 42 days, we'll do everything to try and protect it.
Sure.
Yes.
But
so-
if you ask me, what will be the benefits?
of a
setting the
cross-petition.
record straight.
That he came below.
Setting the record
It's not less than he actually was doing.
No, because
But again, it
you
would
see,
raise
prior
issues
to
about the
let
credibility of the
me
EC,
give you the
wouldn't it?
answer. Prior to the elections, the thinking within the MPP, the intelligence we were picking up is that, Mr. Mahama wasn't going to even cross 28%.
Wow.
Yes.
Those things were
Yes.
said.
So I believe the statement made by the campaign manager, was a reflection of the thinking that, look, I mean, this man didn't deserve to even get 6.2 million votes. Okay? But, the Malene Senior has a very important question. Supposing you cross-petition on that in your answer, all right, you are seeking to prove that he didn't get that number of votes. To what end? Maybe mathematically it could play out this way. I'm just thinking aloud that if we were to say there is enough padding of votes in favor of Akufo-Addo, and the court agrees with that to take those votes from Akufo-Addo, mathematically taking votes away from Mahama on account of whatever evidence they bring may balance it, and then even the playing field and Akufo-Addo still leads. Maybe that is how they are thinking. But
No, my point is that what Article 63 is saying is that cross the 50. 50 plus 1 and you are good.
Okay.
What we have now is 47. So if we go to show that you even got 40, 42 or 28, how would it affect the 50? Because the important
It
is
has to
cross.
set the record straight.
Oh,
So go ahead.
if I were the judge, I would tell you it's not necessary at this stage. Are you proving that he crossed the 50?
You don't strike
It's
it.
the duty of the court.
If you want the claim can be proven, you can strike it off.
If I
If it
were a
can be
judge
proven.
sitting there, I tell you that it's not necessary. Let's concentrate on the 50 plus 1. Because that is what makes a president. It's not lowering the percentages.
But in lowering the percentage of the candidate
for
who is
the-
deemed to have lost, it would mean a certain change in that of the winner.
You still have crossed
Wouldn't
the
it?
They will
Because,
probably.
because look, we're talking about the exactitude of figures.
Yes.
And so there would be a need for that.
Yeah.
Yes,
Even though
yes.
it might seem trivial.
There will probably be, unless those votes are added to His Excellency Nana Dankwa, there won't be an upward adjustment of his votes. They may stay, constant. All right. But the base figure, based upon which the percentage was, the denominator, based upon which the percentage was calculated, will change. And that is where there might be. I mean, there might.
If I'm a lawyer advising, let the NDC show that nobody crossed the 50 plus 1.
Yes.
I'm not
And that's what
interested.
Yes,
Yeah,
that's
that's what
yes.
What I'm saying is, I'm not interested in saying that I want to lower your percentage.
It appeals to the base. It appeals to the base.
That's why I said some political dimension as well to all this. So there's a judicial aspect.
Your base will be very happy.
Exactly.
If Mahama's votes
They
are
will
lower.
strip you naked.
Very well. We need to take a break at this point, but when we come back, we'll be interrogating other sides. We're looking at whether or not election petitions are a means by which losing candidates would seek another opportunity at the presidency by way of their party, electing them as flag bearers or not. And then we'll also look at lessons learned from the 2012 petition and whether or not the EC, by reason of those lessons, was better aided to conduct the 2016 elections and, of course, the 2020 elections. But your guess is as good as mine. We'll see you after the break. This is a key point. Stay with us.
Center is here with all your eye care solutions. Yes, Third Eye Care is at it again. Are your lenses becoming foggy because of wearing face masks or sitting in air-conditioned spaces? Are your eyes getting sore and tired after using the computer for prolonged periods? Are you struggling with light from oncoming cars and other vehicles when driving at night? Worry no more. Third Eye Care and Vision Center has all the right solutions for you. We have anti-fog and blue filtering lenses that solves it all. Third Eye Care and Vision Center also stocks all types of lenses, designer frames, sunglasses, and employs very well-trained, qualified and licensed optometrists to provide all your eye care needs. Locate us at Airport Residential Area, close to the Association International School, opposite Mirage Residence, or Northridge, on the premises of Sunny FM and close to the Kanda Overhead Bridge. Call us on 054-328-7008 or 026-646-2080. Third Eye Care and Vision Center, your total eye care solution.
The assurance that absolutely none can compare. The peace of mind that nothing could ever be better. The joy that comes with being free to be who you are. And the knowledge that where we're from can guide us to where we're going. Key, a tradition of smiles, a future that's bright.
This advertisement has been vetted and approved by the FDA.
It's painful. Plenty broken nuts. Every day they get broken nuts.
The guy I dated for 4 years got married to someone else whilst we were still dating.
The show that gets singles hitched. Date Rush is back.
Yes, I'm single.
It ended because I cheated on a lady.
It's from the family. They don't like me.
The new season of Date Rush is about to start and promises to be exciting.
Where the party there today? Hey mama, hey
how did you get your last girlfriend?
Oh, she was my course mate way back SHS.
So you haven't dated since?
Oh, please.
How long?
Like 5 years now.
Are you a virgin?
Please, no.
The all-new season of Date Rush premieres this Sunday, 3rd January 2021 at 8 p.m. on TV3. Don't miss it. The all-new season of Date Rush is proudly brought to you by Rush Energy Drink, Casapreco Carnival Flavored Liqueur, Ernest Ointment, Heaven Insecticide Spray and Coil, and Napa Foods. The Ladies Circle. Your Saturday evenings are never the same when 4 intelligent ladies are on your screens talking about everything that has to do with women as we get into honest conversations, giveaways, and fun games.
Hi guys, this is Shatamishi.
Sissina So, Zinel Zu. I'm Juliet Ibrahim.
This is the Ladies Circle.
Join the host of the Ladies Circle. Keep watching the Ladies Circle. The Ladies Circle.
Keep watching the Ladies Circle this and every Saturday live on TV3.
Let's get interactive on social media. Facebook, Instagram, and Twitter. Hashtag the Ladies Circle.
The Ladies Circle, every Saturday, 6 p.m. on TV3. Brought to you by
Yaz Sanitary Pad.
Some are born to mime. Some play the saxophone. Some are like Shakespeare. Some carry a tune. Some dance. And some sing to glorify God. For 13 weeks, their quest will be to engage, entertain, and excite the judges and audience on the biggest stage ever. Churched and Gifted.
Churched and Gifted, Sunday at 4 p.m. only on TV3.
Powered by
Welcome back. You're still watching and listening to The Key Points. We're live on TV3, also live on 3FM 92.7, online at 3news.com, also on our Facebook page, TV3 Ghana. So currently in studio with me, we have Honorable Dr. Dominic Ayine, Mr. Martin Pebu, His Excellency Ayikwe Otu, and we're looking at the issue of presidential election petitions. And this is obviously coming against a backdrop of the presidential election petition filed by Mr. John Dramani Mahama on the 30th of December 2020, following the 7th December 2020 elections. I indicated just before the break that we'll be looking at, the very topic of this discussion, which is whether or not presidential election petitions are a genuine means to help resolve or settle doubts around elections, or that people wouldn't necessarily use it to, as it were, keep their base, what's the word? Excited and pushing for another opportunity for the candidate who wasn't successful to have another opportunity to be elected as flag bearer of the party. Before we look at that particular issue, I would want us to look at the 2012 election petition and what it helped resolve. The President, Nana Addo Dankwa Akufo-Addo, back then, the petitioner, indicated when the judgment was given that he disagrees with the results, the judgment, but respects it. What a lot of people have asked then is, okay, so what did we achieve then? We were able to move on after 8 months though, but in terms of the petitioner, did clarity come to bear? He indicated that, well, he disagreed, so obviously he still had issues with it. Mr. Martin Kpebu.
Okay. Yeah, so we achieved a lot, at least in terms of moving our democracy forward. So number one, at least the Supreme Court gave the imprimatur of the legitimacy of the election of Mr. Mahama. So that was good. So it didn't go down in history as an election that was forever contested in the court of public opinion. Okay, because at least people would also readily direct others to the Supreme Court judgment. So it was very important, okay? And also, there were other collateral benefits, okay, to our democracy. You remember the request for further and better particulars. Yeah, we even took it from the legal profession to ordinary usage. The pink sheets, you and I were not there. Even, some even wrote books out of it. So we kind of were building our democracy, okay, in a certain way. So for me, I would say that the 2012 election petition was okay. It was good. It's just the time that it took. And, that was our first time doing it in that major fashion. So, and to that extent, from that lesson, you see how we've improved it by bringing out new rules to drastically reduce. So to that extent, it was good in 2012.
Very well. Doc.
Yes.
That same issue.
I think that the 2012 petition, as Martin has pointed out, strengthened our constitutional democracy. Of course, the dispute settlement process played out on television, for 8 months, and our ordinary citizens associated with whatever was happening. But the other thing is, for me, when the then candidate Nana Addo Dankwa Akufo-Addo said he, disagrees with the outcome, but he respects it, that statement in itself, was also a signal to his base and to the citizenry that they should accept what has happened and let us move on. And that, the judicial outcome may be unpalatable, but that is not a basis for saying that you have to run down the judiciary, you disrespect the judiciary, and so on. Then also, you will remember that when the trial was going on, when the hearing was going on, not the trial, the hearing of the petition was going on, there were a lot of party faithfuls sitting on radio and television and running commentary. Some were running down the judges, others were running down the process, and so on. And I remember,
were consequences.
Yeah, and there were consequences. And I remember distinctly Marlene Senior appearing and pleading on behalf of one such person, and did it in a very spectacular way that, kept
the Popo Blibli and all of that.
Yes, those, I believe, and I don't know what is happening within the MPP, but within the NDC, we have taken that very, very seriously.
Right.
And we are warning all our communicators and telling them that we do not want anyone sitting on TV and running down the judges or the court, or making adverse comments in a way that is prejudicial to the hearing of the petition. And I remember distinctly when your producer called me, I said to him that one thing I would not do would be to go in and discuss, the merits in a way that will violate the sub judice rule, you know, and that will also be prejudicial to, you know, whatever is going to happen.
Sure.
And that's why I was very surprised. I don't know whether you've seen it, but Mr. Gabi Ochiridako posted on Facebook, or is it Twitter, his prophecies in quotes for 2021. And one of the prophecies, I don't know whether it is number 12 or so, is that he is prophesying that the Supreme Court will dismiss the petition on the basis that the petitioner does not have sufficient evidence to prove his a petition. Now I found that really disturbing coming from a lawyer, you know, and the owner of a prominent law firm that has been doing a lot of good transactional work for the government. You know, I think it is unbecoming. You know, it's unethical because you can. That kind of prediction. Supposing, for the sake of argument, that the Supreme Court actually comes down the way he has predicted. What do you think people are going to say? People may even begin to think that the judgment was being written at the time that he was, saying those things. You see, we need to take our, constitutional democracy really very seriously. You know, the whole idea of lawyers, law students, you know, running to town with a lot of stuff. For instance, a lecturer at the Gimpa Law School, you know, went to town. One Mr. Dako went to town writing about the fact that the petition is this and that and that. And
I think we should be circumspect.
That we have to be very circumspect. We have to be very,
yes.
You know, part of what happens in other jurisdictions. For instance, when the UK Constitutional Court was hearing the action that was brought in respect of the prorogation of what do they call it? Prorogation of Parliament.
Yes.
All right. The hearing was live on TV, but what you noted was that the lawyers, you know, would come out and explain what took place in court on that day.
Educational, which is
yes.
why I keep on
you know,
emphasizing that.
And not basically go into the matter. It was after the decision that the lawyers then were free to talk about, you know, everything that, you know, transpired. And I think that's the point that his lordship, Justice Yoni Kulendi, was making. That after they have rendered their decision, we can take it to the cleaners. Yes. We can take it to the cleaners in a law journal article, you know, some commentary, you know, in a newspaper, and so on and so forth. Oh. But before then, we need to be very circumspect. Right. And what happened in 2012, you know, with all those, you know, statements and contempt applications, I think there were about 5 or 6.
We will be going down that lane. Yeah. We'll take a trip down memory lane and see some of those cases involving, you know, the persons who were cited for contempt.
Very well.
We have one involving the late Sir John.
Yes.
So we'll look at that, and then two others that have been prepared for, you know, viewing or displaying on our screen. So if it's ready, kindly let's go and see that.
We appear for the respondent. Yes. Sir John, could you also agree? Although we are not in this court to justify anything which is contained in the summons that has been shown to us. We've studied it. We are also in no doubt at all that this court has power to deal with contempt, and that even if it is not contained in the Constitution, it is still an inherent power given to the courts. But we are also aware of the provisions of Article 1912, which makes the exercise of that power almost arbitrary. But the practice in such matters is to render an unqualified apology. Yes, under Article 19, It's almost arbitrary. It is not defined, and the punishment therefore.
Discretionary. Judicial function, judicial power is never exercised arbitrarily in the place. Don't go there, don't go there. Don't go there this afternoon. No, don't.
My Lord, so, my Lord, in the circumstances where...
Mr. Aikot, if you are heard to the whole world describing the exercise of contempt as arbitrary in this country, it is not proper. That's not what we are taught.
Well, my Lord, I don't want to argue the matter, but that is what is contained in the Liberty Press case that I intend to rely upon. That is how my Lord, the Chief Justice, described it. That is almost arbitrary. So one should be very careful when you are faced with contempt. So I know exactly what I'm saying, my Lord. But with the greatest respect, I go along with you because at this stage we have not come to argue with the bench. What we are asking for is to show mercy.
You use the word in any derogatory.
No,
you only wanted to show
the serious
immense powers that this court has in dealing with such.
Exactly, my Lord. Now, my Lord, the practice has been to show remorse, apologize for whatever has been said, and in fact, apologize unreservedly in the circumstances. So that is what we are doing on behalf of our colleague, Sir John, who happens to be my classmate and callmate as well.
You may go and stand, don't sit down, but stand behind these people. There's a second case. I thought you would show some power here. He's laughing confidently. These people, some of them have to be watched very, very closely. Can't be sure that this man, there's a change in him. We have to watch these things for the sake of the security and happiness of this country, to which the Constitution has given entitlement to everybody. Few people feel they can take it away. Yes, the second.
I'm sure you must be sweating by now.
Anyway, yeah, there's a second one.
Right, so that was a recap or playback of events from the 2012 petition hearing. That was a contempt case, and as indicated just before we showed that, we're looking at how we need to be circumspect in discussing, the issue as it pens before the court. And so for people who are thinking of doing anything contrary, well, they should look at that tape that we just showed and perhaps have a second thought and not do that. But we do have His Excellency Aikot right here. And I think we had that split screen there showing him and some event from 2012. Tell us, what was going through your mind on that day?
Well, as I said, this is a very difficult situation when we all know the law. That was my call mate, and you cannot assume that he acted in ignorance. So clearly, one needed to do all that you could in trying to assuage injured feelings of the bench, because I heard the story myself, as I keep telling people. I think on my way home, and there was this net tube, the radio one. Yeah, in the evening, at close coming, when I heard some of the things being said, I got frightened. Then it fell upon me to go and defend, and it happened to be 14th of August, which was my birthday.
Oh my God!
So
I think I remember you.
It was a huge, issue for me the whole night. How to go about it, planning in my head, and
strategizing,
strategizing, because you have to look at the bench. Sure. and then you start, and then you hope that nobody stops you.
Heckling.
Where nobody heckles you, and then gradually you build up, and then you can get to wherever you want to get to. But if you are not lucky, and you start, and then they come down on you heavily and start heckling, it will not end well.
Right.
But that day,
I think you had a birthday present.
We had a birthday present.
But others were not lucky. Some were actually
It's because of the approach then. If you go and you want to go and argue and
so let's go back again
so
down memory lane to see one of that where, those persons that were not lucky and actually had custodial sentences being put on them. So let's take a look at that.
I'm just a poor boy from Binduri. I'm not from any fancy family, and I come from a very poor home, Your Honor.
So you learned the slangs from your poor family?
My Lord, I've lived in the United States for 14 years, my Lord.
This is what I suspect. In the United States, the law works irrespective of anybody?
Yes, my Lord.
For that, you're very that's the first thing that anybody who has been to the U.S. for some time cannot miss out from. And you come back here with that experience, instead of trying to help build your country in a better way, you just put it aside.
I apologize, my lords, and I take full responsibility for my irresponsible actions. I apologize, my lords.
From the publication, you wanted to be a member of Parliament for Binduri. So this is the kind of leadership you are coming into leadership position in this country, and we should sit here and allow that.
We can be confident that Mr. Tubiga is going to respect what he has said before your lordships about using the platforms to withdraw unconditionally the harm that is done with those words. I would agree with your lordship that the harm that is done by these words are significant, and therefore all I'm asking respectfully for is that, as he himself has asked for, you temper justice in this case with mercy, and that he be given the chance that he has asked for. I'd just like to say one small thing, that it does suggest to me that some media houses are also unduly misrepresenting your lordship's intentions, because now we have a situation in which the gentleman says he was not even there on the occasion. There's an attempt to say that he was there on another occasion and so on, and that also he says is not true.
You can find a comfortable seat.
Hello, thank you very much.
I appear for Ken Crunchy. My name is Atta Achian. So, my Lord, what has happened is that I'll crave your indulgence to have a very elastic heart in trying to understand where my client is coming from, because some lawyers are very confused.
Are you one of those confused lawyers?
My Lord, far from it.
Then confine your comments to yourself and address the issues.
Yes. If you read between the lines, he's not prejudging the matters before the Supreme Court. Ken Crunchy clearly says that Samuel Awuku was right in describing us as hypocritical and selective. A thing Samuel Awuku himself fully retracted and apologized to this court. If this is not defiance of the authority of this court and the due administration of justice, we do not know what else it can be. We have no doubt that the said statements are made with intent by him to defy the authority of this court and the due administration of justice. Accordingly, we find him guilty of a criminal contempt of this court and sentence him to 10 days imprisonment.
Right, so a trip down memory lane showing what happens when you're not circumspect with, how you go about talking about a matter that is pending before the law court, and in this case, specifically the Supreme Court. 10 days imprisonment sanctioned.
It could even be more. I mean,
It could
I'm
be,
sure,
exactly.
I'm sure they were just being lenient.
Yes,
with
exactly.
with
So,
them.
I mean, they say a word to the wise is enough. That's what it is. So it's just for us to know that, yes, this may very well last 42 days or more, but in that time frame, obviously it's a matter of public interest. We cannot not talk about it. We will talk about it, but let's just be circumspect in doing that. I think that's the key word. Now, Mr. Kwebu, your thoughts watching that? Some 8 years ago.
Yeah, I do remember that time, what do you call it? There was a lot of excitement in town, yes. And then when the convictions were handed out, especially to Ken Crunchy, then there were issues of looking at it. Could it have been avoided, But I remember people taking on counsel for Mr. Crunchy and the rest. But look, the way I see it is that these things in court, there's no way you can always avoid them. No matter how you are careful, on some days you will slip. Or you would think that you're doing it the best way, but the judge doesn't see it that way, and then they may come down hard on you. So it just tells you that, well, it's part of the game. That's what they mean by, as lawyers, you win some, you lose some. Okay, yes, but it's taught our citizenry, and it's even good you've played it back today, that we should be circumspect, and just as you admonished us. So that is very good, especially going into this current petition, that we are circumspect in the utterances, so that we give the judges the required space, the judges and the parties the required space to be able to prosecute the case well, so that our democracy will come off the better.
Sure. Now, Doc, still on the contempt bit, it's an area that is quite interesting. For a number of reasons. But in recent times, we've had the Supreme Court make pronouncement in a matter involving the Honorable Kennedy Japan, which had to do with a land court judge.
Yes.
And I think the Supreme Court indicated that the matter, as at the time was being heard by the judge or the court against whom this alleged contempt was committed, could not proceed to hear that matter. And so the directive was that the AG should take it up, initiate that action, because in effect it's looking like you would be the complainant, the prosecutor, and then ultimately the judge, which would raise issues. Now, looking at this recent decision, do you envisage a difference in procedure from what happened in 2012?
No. With all due respect to the Supreme Court in that case, I read, I haven't read the decision in full, but I read aspects of it, all right? But you have beautifully summarized it. I think the court was patently wrong.
Let me add something to that. I think it boiled down to the bias. They say they made a case that there was hostility.
You see, go back to the common law. The power to commit for contempt, either ex facie courier in the face of the court, or a contempt that is outside of the court. Statements or actions geared at, bringing the administration of justice into disrepute. That is the only instance in the common law where it is acceptable for the judge, to be a judge in his own cause. Now, also note that contempt is not one that is impersonal, in the sense that it is against the judge. All right. Yes, the judge mans his court, but it is the institution of the court which is being protected by the power to commit for contempt. Okay, because if that were not the case, litigants, their relatives or persons who have a pecuniary or other interest in a matter could simply, run down the court, and go scot-free. So for me, I think that the court was wrong. It's with all due respect to His Lordship Justice Yoni Kulendi, he was patently wrong in that decision, and I hope that the court will have an opportunity to take its words back. Because, you see, a judge should be able to commit for contempt. It doesn't matter that the words were uttered against that same judge. In the common law world, review decisions in the UK, in the US, where we have taken our legal tradition from. Judges commit for contempt even when it is against their person. They are the ones who are sitting on a case and a comment has been made against them. They can sit and commit the person for contempt. So because you see, if you say that objection that was taken, I found it really strange. That an objection should be taken that the judge would be, a judge in his own. I mean, this was the first time that it was taken, and I found it really very strange. And I thought that the Supreme Court was going to tell them, you know what, go back to the High Court and then purge yourself of the contempt. If we don't take time, the power to commit for contempt and the protection that it affords the judiciary will be whittled down. Because you can't sit on television, national television, and say that you deal with a judge, you do this, you do that. And then subsequently when the judge says you should be committed for contempt, then you say, let another judge be the one to determine whether or not I committed contempt. But those words, were prima facie contemptuous of the court.
Some would say that, those comments were made outside of the court.
Yes.
And so it wasn't one before the court, and so the courts then would not necessarily have to deal with it there and then. And so remove yourself from that process.
In being committed for contempt, all right, they had the documented evidence of what he said, and all that the judge was going to do is to say that, come and show cause why you should not be committed for contempt. And I don't think that is too much, for any High Court judge to do.
Very well. Mr. Kwebu, your thoughts on that? Because I'm asking this question because, like we saw from the playback of 2012, contempt cases came up during the hearing of an election petition, and it did because it was televised. And I'm sure that precedent will be followed now by in the sense that this one would also be televised. Yeah. Obviously, it's in the interest of the country.
Yeah, we pray because the rules say the court may. So we are praying
would allow it not to be televised. In fact, the citizenry would want that. So again, we are treading or veering into an area where if people are not circumspect, then we are likely to have a playback of contempt cases happening. And if they do, would this new decision by the Supreme Court be what would go? In fact, we do know the Supreme Court can depart from its previous decision, obviously, within the context of law. But how do you see that happening, the difference in procedure, 2012, 2020, in view of the current position espoused in the Kennedy-Japan case?
Okay, so the Kennedy-Japan case, as I chipped in earlier, it's number one. You see, I'm handicapped to the extent that I wasn't in court. I only heard reported speech, So as a lawyer, you are very careful. When you are not in court, you are very careful to be categorical about things that happened in your absence. So because of that, I'm being careful. As I said, what we were told was that they said the court was satisfied that it appeared there was hostility between Mr. Japan's lawyers and the judge. That's what we are told. As to what actually happened there, I don't know. So it was based on it that the court ruled then that the case should be given to another judge, you see. So for me, look.
So that's a distinguishing element.
Yes. So, but remember that, you see, we live in a society where the society expects substantive justice. They don't like this legal rigmarole, and then at the end of the day, there's no justice. So the best way to resolve this thing is that the directive that was made that the case be put before a different judge, please, let's carry it through. Let's carry it through, because it appears this case is just, going to go away. Mr. Japan must face justice. The case must go on. It's been how many months? We haven't heard anything about the case. The other day, I heard somebody saying that he went to follow up. He didn't hear anything. Please, if not for anything at all, what your station should be interested in is that maybe, we are resuming on the 8th. So a week after, let the reporters go and see the Judicial Secretary. Okay, what is the latest on the case? Because we can't take that situation. We won't allow it in this current dispensation. Those comments must be scrutinized in the court of law. If it's contempt, then we will know. If it is not, we know that I don't for one moment want to accept that it appears the strategy is that, oh, just let it lie where it is. People will forget. We don't intend to forget. We will never forget that case.
Very well.
It must be dealt with in a court of law.
Notices
and that will
advised.
help make up for whether there was hostility or there was not.
Very well, that's fine. His Excellency, any thoughts on that? I mean, you experienced that back in 2012.
Yeah.
And in view of this new decision, how is that likely to impact, processes going forward with regards to the John Dramani Mahama election petition?
Like he said, I don't think we've seen the full text of whatever ruling was given. These were reports that we heard of. I'm not sure I've ever seen it yet, the full ruling, and whether it was just a matter of transferring the matter from one judge to the other, or saying that judges can no longer commit, but only for the Attorney General to, intervene. I don't know, but looking at the Constitution, Article 1262 makes it clear that the superior courts shall be superior courts of record and shall have the power to commit for contempt to themselves.
Yes.
And all such powers as were vested in the court of record immediately before the coming into force of this Constitution.
Yeah.
So it is not only a common law matter, but it's a constitutional.
Yeah.
Again, if you come to Article 19, 11 and 12, which I was referring to, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed in a written law. But at 12, it says clause 11 of this article shall not prevent a superior court from punishing a person for contempt of itself, notwithstanding that the act or omission constituting the contempt is not defined in a written law, and the penalty is not so prescribed. You see the arbitrary. So that is what makes it a little bit arbitrary, that people should be careful that even if the thing has not been well written and defined, you can still be punished for contempt. So just don't take things for granted that you should at all. If need be, just veer off. Like we are discussing, let's have a general discussion on the matters. And don't go attacking judges left and right. It's not the best because, like Doctor said, it is the institution we are dealing with. It is not the judge per se who feels wrong. But what about the institution? If you bring it, you lower it in the estimation of right-thinking members of the public who will have confidence in that judiciary. And that is the only place where you can have matters settled in peace without cudgels and sticks and knives and other things. So let us promote it and let people feel that that is a place to go and you have justice. And then let us remember that the whole idea of the hierarchy of courts is that if you feel that you did not get justice at one place, move on to the other stage. But let me just add quickly in the Walensee case that if you go and file an election petition at the High Court and you lose and you file an appeal to Court of Appeal, that's the end of it. Don't try and say you are going to Supreme Court.
But an appeal is by way of, it's provided by statute.
It's a creature. If it's not there, it's not there.
Very well, that's fine. Still looking at the 2012 election, I think earlier on we talked about the fact that, yes, there were lessons learned, it helped our democracy in general and all of that. But I want us to look now specifically at the work of the Electoral Commission. Because obviously with the election petition on our hands now, the role or the work of the Electoral Commission has come under scrutiny again. So if indeed there were lessons learned from the 2012 election petition, do you think that those lessons helped with the work of the EC in the 2016 elections, indeed the referenda that came in between, all of that, the by-elections, and particularly looking at 2020? And Doc, I would want you to start with that.
Yeah, you are right, Abena, in saying that the election petition, focused attention on the work of the Electoral Commission. And rightly so, because the Constitution vests the power to organize, and conduct elections in the commission, it is the sole constitutional body responsible for the conduct of elections. Okay. And so its work necessarily comes under scrutiny when there is a dispute. As an election management body, the 2012 presidential petition exposed some of the deficiencies, okay, and I'll say inefficiencies in the way that the elections, it was managed. So, for instance, there was this famous issue, which at the time I described as a non-issue, of pink sheets with same serial numbers. It featured so prominently in the litigation, whereby ordinary people from my constituency would call and say, but this issue, what pink sheets with same serial number, how did it happen? And the idea that I think Baumia was very articulate in bringing to the limelight the possibility that the coincidence of serial numbers in various was a rigging tool. All right. However, it was just a printer's devil. Okay, I got to know this subsequently when I started. I was nominated by the minority to be on the ETC, that is the Entity Tender Committee of the Electoral Commission. Then, in interacting with the top, management, I got to realize that issue arose because when they printed the pink sheets, all right, there was a shortage, and then Afarijan asked the printer at the last minute, to print more. Now, according to the explanation that I got, usually the printers, they have a template, okay, and at that point in time, to dismantle the entire system and then be able to print further so that serial numbers would not differ was going to create a problem for them. So they then just went and used the existing template in printing more. That is how come that
run copies of it.
To run
literally.
Very much like running copies. I'm sure those who are well versed in printing technology will explain it better. But this was an internal decision that was taken that then
had
caused
consequences.
Yes. So for instance, a pink sheet in Zorungu Catholic Social Center polling station A coincides with that in Kumawu Roman Catholic Church polling station B. They have the same serial numbers. All right. What is what do you call it? What does that have to do with rigging of an election? But of course, the election management body should have done a better job of ensuring that doesn't happen, because it then raises, suspicions. So I think that this is just one example of some of the issues that were raised about the work of the Electoral Commission. All right. In the current petition also, I am sure they are going to come under scrutiny, for some of the things that, they did. And of course, I'm not going to go into, the details, because we have pleaded them in the petition. But what I can say about the Electoral Commission is that it has come a long way. But typical of a Ghanaian institution, I don't think that they are learning, from the mistakes of the past. Because you remember recently there was a talk of printing of ballot papers, that were not authorized, or no, that did not have the agents of the parties, present and so on. Because there are time-honored practices that the Commission has adopted, to ensure that there is no suspicion that it is, in cahoots with, the parties. Do you get it? And I think that those time-honored practices must be adhered to. Because we are still, we have done how many years? Is it 28 years of democracy? But we are still a very young democracy. Okay, America has over 2 centuries of democratic, governance, and we haven't been able to do half a century yet. And so there are time-honored practices that the Commission adopted that have served us well as a country. Okay, they should stick to those practices and make sure that they finesse them in order to build public confidence in the work of the Commission. So, for instance, one last example that I want to give, and then I'm sure His Excellency and then Martin will have something to say about the EC. Usually ballot boxes are carried in the Commission's trucks, okay, accompanied by the party agents, okay, and then the police to the final destination where they are lodged. In this particular election, the Commission decided that they were going to use motorbikes to carry ballot boxes from the collation centers, constituency collation centers to their final destination. I witnessed it live in my own constituency, and I protested. All right, and I remember telling Mrs. Jim Mensah, who, by the way, happens to have been my classmate and friend, very much like His Excellency and Sir John. We started from the law faculty all the way to the law school. I told her, I said, there's a time-honored practice of having the Commission's truck come for the ballot boxes with party agents accompanying them. That has built some confidence into the process of protecting the ballot, so that you don't have a situation where a motorbiker takes the ballot on his way, maybe an accident occurs, and he's alone there. All right, or he then decides, if he's in cahoots with any of the parties that took part in the election, that he's going to allow them to put more ballot papers into the ballot box, despite the fact that it might have been recorded on the pin sheets that this is the number of ballots in that box. In subsequent litigation, it could be an issue.
Definitely.
Those time-honored practices, must be adhered to. And for instance, I think they have to take IPAC very, very seriously. In fact, I'm one person who has been saying that we need to write IPAC into the public elections law.
Very well. We'll take a break at this point, and when we come back, we will wrap up on how the 2012 elections petition, helped with the EC's work, and then we will go look at whether or not election petitions are a genuine attempt to help resolve challenges or problems or some other purpose. This is a key point. Stay with us. We will be right back.
With schools temporarily closed and students staying home, teachers at North Hills International School, the most preferred private school in Ghana, award recipients in 2018, continued to have constant interactive classes with our pupils while simulating classroom experience online. At North Hills International School, we adapt to change and we go the extra mile to make sure any investment made in your ward's education yields the best results. We admit students from preschool to junior high school. Our arms are open to welcoming your ward into our wonderful community. Call us today and let your child start a promising journey of global excellence with us. North Hills International School, climbing academic excellence.
High sense movie chapeau. High sense bronya. 15th December, couple 15th January. What you want? Ni atete ni amane so say. What you say? High sense ni ama. Eye papa. Ne nyam kanian so. High sense pen out of over. Yama 5 years warrant. Hey. Hema 5 years warranty. High sense niema ni nyina. Ya tete so. Every television, refrigerator, chest freezer, air condition, gas cooker, electric cooker, washing machine, mobile phone, sound system, microwave oven, blender, iron, rice cooker, water dispenser, kettle, steamer, any be break home. High sense no nya. 15th December, 15th January. January.
Hisense showroom beer. And then maybe all beer. Yeah, that's just so.
Extra sa obeko Hisense showroom beer na oni abedija. COVID-19 wo hihye beer. Ye de gu akwam.
Thank you for your appreciation. I love that.
Hisense. Everyday prices for everyday people. And your Hisense bronya.
It's painful. Plenty broken nuts. Every day beer they get broken nuts.
The guy I dated for 4 years got married to someone else whilst we were still dating.
The show that gets singles hitched. Date Rush is back.
Yes, I'm single. It ended because I cheated on a lady. It's from the family. They don't like me.
The new season of Date Rush is about to start and promises to be exciting.
Why the party there today? Hey mama, hey I ever say.
How did you get your last girlfriend?
Oh, she was my course mate way back SHS.
So you haven't dated since?
Oh, please.
How long?
5 years now.
Are you a virgin?
Please, no.
The all-new season of Date Rush premieres this Sunday, 3rd January 2021 at 8 p.m. on TV3. Don't miss it. The all-new season of Date Rush is proudly brought to you by Rush Energy Drink, Categorical Carnival Flavored Liqueur, Earnest Ointment, Heaven Insecticide Spray and Coil, and Napa Foods.
How safe is your environment from pathogens? How do we survive this new normal with bacteria and viruses everywhere? You can take charge of your environment by using Good Air Sans Humidifier with chlorine dioxide tablets to get rid of pathogens, including bacteria and viruses. You can use Good Air Sans Humidifiers in your homes and offices and be rest assured of protection against pathogens. Just set up the Good Air Sans Humidifier in your space to disinfect the place continuously for virus and bacteria-free environment. Our devices work in both public and private spaces like schools, hotels, hospitals, churches, mosques, restaurants, salons, and homes to enjoy a nice family time. Good Air. This advertisement has been vetted and approved by the FDA.
It's painful. Plenty broken nuts. Every day beer they get broken nuts.
The guy I dated for 4 years got married to someone else whilst we were still dating.
The show that gets singles hitched. Date Rush is back.
Yes, I'm single. It ended because I cheated on a lady. It's from the family. They don't like me.
The new season of Date Rush is about to start and promises to be exciting.
Why the party there today? Hey mama, hey I ever say.
How did you get your last girlfriend?
Oh, she was my course mate way back SHS.
So you haven't dated since?
Oh, please.
How long?
5 years now.
Are you a virgin?
Please, no.
The all-new season of Date Rush premieres this Sunday, 3rd January 2021 at 8 p.m. on TV3. Don't miss it. The all-new season of Date Rush is proudly brought to you by Rush Energy Drink, Categorical Carnival Flavored Liqueur, Ointment, Heaven Insecticide Spray and Coil, and Napa Foods. The Lady Circle.
Your Saturday evenings are never the same when 4 intelligent ladies are on your screens talking about everything that has to do with women as we get into conversations, giveaways, and fun games.
Hi guys, this is Shatamishi.
Sissina So, Zinel Zoo. I'm Juliet Ibrahim.
This is the Lady Circle.
Join the host of the Lady Circle. Keep watching the Lady Circle. The Lady Circle.
Keep watching the Lady Circle this and every Saturday live on TV3.
Let's get interactive on social media. Facebook, Instagram, and Twitter. Hashtag the Lady Circle.
The Lady Circle every Saturday 6 p.m. on TV3. Brought to you by
Yaz Sanitary Pad.
Girls like us, and then also women.
From deliberate mentorship of adolescent girls produces a responsible generation. That is why Because I Want to Be is brought to you by UNFPA, Rebecca Foundation, Canadian Embassy, Merck Foundation. Because I Want to Be shows Sundays at 1 p.m. on TV3.
Welcome back. You're still watching and listening to The Key Points. We're live on TV3, also live on 3FM 92.7, online at 3news.com, also on our Facebook page, TV3 Ghana. So we're still looking at election petitions, presidential election petitions, and in the studio we have Dr. Dominic Ayine, also Mr. Martin Kwebu, and His Excellency Ayikwe Otu. Here, we're trying to reach a fourth panelist via Zoom. When we do that, we will definitely do the needful and introduce him and get his perspective on the issue as well. But just before the break, we're looking at how the 2012 election petition, presidential election petition, helped with the work of the Electoral Commission in other elections or subsequent elections. So you're looking at the 2016 general elections and the 2020 elections as well. I will be going to Mr. Kwebu and His Excellency Ayikwe Otu. But before that, let me quickly introduce Dr. Hayford Nsia. He has joined us via Zoom. He is all the way in Alabama in the United States of America. He's a political science lecturer at the Auburn University. Good morning, Doc. Can you hear me? Hello? Okay, we'll try to work on the audio there. But before that, let's get back to the panelists in studio. Mr. Kwebu, let me come to you on the issue about the EC and how it's been, how its work has been assisted by lessons learned from the 2012 election petition. Let's try again to see if Dr. Hayford Nsia can hear me. Hello, good morning, Doc.
Good morning.
Good. How are you doing? It's good to have you.
I'm doing very well.
Great. So you're all the way in Alabama, but I believe you have your eyes and ears right here listening and looking at things happening in Ghana.
Yes, I am.
Right.
But I've been monitoring the...
Sure. So currently we have...
We
have the presidential election petition filed by former President John Dramani Mahama pending, and obviously we're not going to look at the merits or demerits of the matter because it's before the court, but we're looking at election petitions, presidential election petitions in general. We have in the studio here 3 lawyers. They've given their perspectives on the whole situation from the legal point of view. We are coming to you now from that political science dimension, because obviously we do know that the process, in as much as it's judicial, there's some political dimension to it as well. Let us know what you make of the happenings so far.
I strongly believe it's a way to deepen our democracy by strengthening the institutions that are mandated by our constitution to superintend the election processes. When such matters come up, even though if you look at it from the political economic point of view, it brings some level of uncertainty when it comes to business and investors. It makes them adapt that wait and see approach. They want to know what will happen before, if they want to invest. Other companies or investors may end up practicing what we term as the cash buffer, or probably trying to diversify to look at other countries. But such election petitions, for me, they are not evil, they are not wrong. It tests where we stand. It really tests where we stand as a country when it comes to the strength of our democracy and what we do to strengthen these kind of institutions. So it's in the right direction.
Right.
We are just waiting and hoping that the trust that we have in our judiciary, they will be able to come with the ruling that will really affirm the kind of position that we have we've raised when it comes to our democracy and push us forward to become the light, or to become more like an example to African countries to learn from us.
Right. Now, question is, very well. So yes, the general benefits or importance of this petition, as you've indicated, is very clear. It's sanctioned by the Constitution law. But in terms of the base of the party whose candidate is the petitioner, what does such a petition do for the base? In this regard, we're looking at some more than 6 million people who voted for this candidate, but obviously didn't, as far as the declaration by the EC goes, didn't make the mark that is needed, the 50% plus one, or more than the 50%. What does this kind of petition do to that support base?
For me, I think it shows that the support base, when it comes to the political parties or the candidate, we've reached a point where we don't just vote because of our tribal affiliations, just our loyalty for the party, but we look at the substantive issues, policies that are at stake. So, looking at the numbers that the president-elect, let me put it that way, obtained, and then our former president, John Mahama, also obtained, it shows that we are growing in our democracy. I don't think it will really put any pressure or it will bring doubt on the mind of voters. It is taking us to a point where this election petition will confirm the strength that we've gathered as a country and our understanding of election when it comes to Africa, or let me even put it sub-Saharan Africa.
Now, I ask that question because of this assertion out there that, well, perhaps people losing candidates, if you like, would resort to an election petition just so that they'll be able to galvanize their base with a view to getting an opportunity for, being elected as a flag bearer within the party for the next election. And what's your view on that?
For me, it's not wrong. There's nothing wrong with that. Because at the end of the day, even if you use the election petition to strengthen your support base, when your party re-elects you as their candidate for the next election, it doesn't end there. It's still up to the registered voters to decide whether they are going to give you that mandate, that privilege or the opportunity to lead us as a country. And besides, when it comes to the ruling, the judges are not just going to sit there and then just use their own bias to make a decision. They are going to look at the merit of the case and the evidence that was brought before them. So whatever judgment that will come up, sometimes even if you are not careful, the judgment will even push your support base to lose confidence in you, because they expect that you should be able to take the right kind of decision. You should be somebody who will be able to look at the pros and cons of your actions and take the right action that will put the political party in the right position when it comes to the mind of voters, so that they will vote for you again. It can even lead to a point where people might be thinking that you don't really know what you're about. You just want to prove a point that you really did not lose the election, when indeed you did. So it will sound as if you don't really have policies. You just want to make a baseless point. Like one of the panelists was saying, initially when the former president Mahama was claiming that he has won the election, only to submit the petition, and he's now telling us that he doesn't believe that anybody won the election, though there must be a runoff. When I read that, it took me aback a little bit, because, and I believe strongly that even if it should result in a runoff, that statement he made, what the NDC party did, probably might push certain kind of voters away from them.
So it's quite interesting that you bring up that issue, because I would want to know the significance of such a statement prior to the filing of the election. Politically, what significance does that have on, perhaps the internal politics of that particular political party. And I'm asking this question in view of the likelihood or the potential for there to be, another primaries to elect a flag bearer for the next election. So what is the political significance of such a statement? We can't, it's not in dispute. That statement was made. And like you said, it wasn't in the petition, such a relief that was being sought. So we cannot discount that or disregard that. It was made. But what significance does that have for the petitioner himself and the party he represents?
Well, for the party he represents, I don't think at this time they will be able to say anything. But if the next 4 years anybody should contest former President John Mahama, that person can make an argument that President Mahama is not trustworthy because he made a statement that he couldn't substantiate. And for that matter, they shouldn't give him the mandate to lead that great NDC party again. That's what I believe. Politically, that's the way.
That's a political significance of the statement or the consequence of the statement.
I strongly believe that's what it is.
Well, in wrapping up with this conversation, what would you advise the party the petitioner represents to do? Obviously, they are behind him, supporting him. But beyond that, what would be your advice or recommendation going forward?
See, at this point, if you are part of the NDC, this is the time to show your loyalty to the party. This is the time not to say anything bad or anything that will really tarnish the image of the presidential candidate. They have to support him. They have to be behind him. But they shouldn't be making statements that will really incite violence. They shouldn't be making any statement that will downplay the integrity and the trust that we have in our judiciary. They shouldn't do that, but they should be behind him. They should support him. It's a great party. For President Mahama to be able to get that number of votes, it shows that people love him. People have really accepted him. They were able to sell their policy ideas.
That's why.
So for now, they should be behind him. They shouldn't make statements that will really downplay the trust that we have in the judiciary. And they should also, when they rally behind him, it's a sign that indeed we are deepening our democracy as a country.
Very well. I think we can end it here. And we've been speaking with Dr. Hayford-Nsia. Thank you so much, Dr. Hayford-Nsia. We'll be getting back to you definitely as we go along with this petition that has been filed by Mr. John Dramani Mahama, former president. But we do appreciate your perspectives here. So that was Dr. Hayford-Nsia, political science lecturer with Auburn University, Alabama, United States of America. Yeah, Doc, I see you nodding.
Yes, I think he made a really fantastic point, at the end. He's a true political scientist. The point he made about the fact that the base of the NDC, has to stand behind his candidate, I think also applies, to the base of the MPP. Because at this point in time, they need to also, support His Excellency Nana Addo Dankwa Akufo-Addo with respect to the votes that have been declared in his favor and so on. And then also, I was also nodding because of the point he made about our supporters not making any statements that will in any way, prejudice, run down the judiciary. I'm very passionate about that. I think that we should be careful that we are not in any way seen to be antagonistic to the judiciary, because it is the judiciary is the last bastion of our democracy. The last when we're in law school, there was this product that was being sold, and Makola, our school, the law school is in the middle of Makola. And I remember they used to call it Pepe Last Stop. And we would be in class and we'll be hearing Pepe Last Stop, Pepe Last Stop.
It's a trap.
It's a trap for bats.
For mice.
For mice. Yes. So the judiciary is our Pepe Last Stop. Because No constitutional democracy will survive, I mean, without having that third, arm of government being neutral, a neutral arbiter of disputes, political disputes and so on, so that things don't spill onto the streets and cause civil strife and civil war.
Very well. Yeah. That's fine. Yeah, so let's have His Excellency's take on the role of the EC, its work, looking at the outcomes and lessons learned from the 2012 election petition. I think Doc, before the break, did talk about a few of those.
Let me make a general observation. You see, when you are in opposition, you seem to see the EC as being in bed with government in power. And
the director of elections, Dr. Sribok, said something funny. The EC should be pregnant by now or something like that.
You are always attacking the EC. And my worry is that the EC, although it's not like the judiciary, refuses to come out to explain issues. Right. You see, they have to strengthen their PR area. Let them give us the information. So long as you have information, you can digest it. What happened between the 9th and the 10th? Some results were declared. On the 10th, other results were declared. What was the difference? Why did we have a second,
set of numbers?
But I am not sure that I've had the opportunity to really go into the matter, except that there was a press release. Looking at the petition, it is their case that even the release was not signed.
But you see, His Excellency, the press release that was issued by the EC did not say the change in numbers was as a result of subsequent declarations, but that she made an error in using a certain figure to represent the total, where in fact it was a certain number.
Exactly. Yeah. The point I'm making is that, so who should throw light on this to enlighten the public? Because up to now, that matter has landed us in court. Somebody is saying that the figures were not properly done, that this figure was put, that figure was put. My understanding simply is that the rejected ballots were deducted. Why was this not made clear that under Article 63, you can only base your percentage on the valid votes cast and not the total votes, which includes rejected ballots? This has continued to dodge our way. I used to say when we were in opposition that yes, like the IBED, the EC is trying to assist. So. But at the end of the day, it's a creature of statutes. Everything it does is by law. Just go and look at the law and see whether it's done the proper thing according to what the law says it should do. The law says pass CI. Anytime you want to communicate something to us, do it by a constitutional instrument. This thing will go and be laid in Parliament for 21 solid sitting days. All the parliamentarians will be there. They will look at it. At the end of the day, CI 127 came into force. Yeah. It did not include certain things. Nobody raised a finger in Parliament. Yet later on, complaints were made. Oh, why don't we use national insurance card? Meanwhile, the thing was not part of it. And it went to Parliament. A Supreme Court declares that this is what we are working with. This is the law. The EC had just applied their laws. Hey, it says birth certificates are no longer of any value. The Supreme Court never said so. So it is not part of the CI 127. So I think they have to do more, engage the public more. It doesn't spoil anything. It's not the judiciary. It's a judiciary that tries, to withdraw and then allow the Bar Association to fight on their behalf. But you are a body set up by law. People are attacking you for certain things you have done. Come out. Say what you know about it. That nothing untoward had happened. We did this and we did that only. And that, I think, may put matters to rest. I am not sure.
Would have stopped the NDC or the petitioner, the candidates at the time, from having the concerns or the suspicions they had?
Well, explaining matters to people will let some of that group, that inner group taking decisions, maybe have more information to know whether what they are going to embark upon will be of any substance or not.
So now that at least Doc is here, let me throw that question quickly before Mr. Kpebu comes in. Would that have solved anything for you?
Well, I mean, part of the reason why the petition has been filed is to hold the institution accountable. And accountability simply means, compelling them to come out and explain and justify their actions. And I think that is what Marlene Sina is simply saying, that when you provide information, when you come out and explain your actions, it becomes, less contentious. And maybe, as you are saying, some people within the NDC would have said, well, but you see, we have an explanation that puts the matter to rest. All right. Maybe if those people prevailed, then we'll not have, a relief in the petition that deals with this, this issue. So the issue of accountability is, really very important. They are not a judicial body. So that is why Senior is saying that. They are allowed to come out and talk, and they should strengthen their PR.
Very well.
Yeah,
Very well. Senior, if you can continue, please.
So you see, with every election, they try to bring out the CI. This time it was 127. The new things that have come out. Yesterday I was reading somewhere in social media that a founding member of the MPP is asking the question, why fix if it's not broken? But what happened is all contained in the CI 127 as to whether the summary sheets should now be brought from the region straight to the... These are all contained in the 127, and it was laid in Parliament. Why didn't anybody say that nothing is broken, don't fix anything? They have gone according to their law. They've declared results. Now there is a backlash. So I think that it also behoves on you, the media, as the fourth estate, that when these things come out, you call them to the studio, and have a panel discussion. What is new on the CI 127?
You mean the EC?
Yes.
We have them.
What's that? What is new?
So easy to get them.
I know. That's the point I'm making.
We do get them once in a while, but
that we are going to have election in 2020. You have passed the new CI 127. What is it? What does it? What are the new things that you have introduced? So people will become aware. But people go out of their way to argue and condemn the EC only for somebody to draw their attention. But look at regulations, so and so 127. Is that not what is provided in the law? What has the EC done wrong?
Complied with the law as it is. Very well. Now,
that's my take.
Your thoughts? 2012 election, petition, lessons learned. Have we seen any impact on the conduct of elections or the work of the EC generally?
Yes, a lot. I'm sure that in itself could be a full program. But let's see the short ones. So the first one, I checked with Dr. Ayeni because he's been deeply involved in the last elections. One of the key things, and he touched on it in his submissions, the pink sheets not having serial numbers in the last election petition. It was huge. If the court had decided that the lack of serial numbers meant that the votes were not valid, it means we would have gone for a rerun. So that was one of the issues that all the 9 judges agreed that could not nullify the vote. There were 3 things all the 9 judges agreed. The pink sheets not having serial numbers, the unknown polling stations, unknown polling stations, and then the polling station codes, some were repetitive. For these 3, the court took the position that they were administrative and could not tamp the sovereignty of the people. Okay. Otherwise, we're bound, if they had said yes, this would affect. It means we're likely to go for a rerun because those were widespread in Africa. So Doc tells me that in this last election, the pink sheets were serially numbered. So that's a good an improvement. Okay. Now, and then you would see that the court went on and on about the way the EC failed to have the serial numbers. Yes, you see the opinion of Justice Doche. He was scandalized when Dr. Afarijan tried to explain the reasons for the duplicate serial numbers. Yeah, he was truly scandalized, and he went on to wrote certain suggestions for reforms.
Sure.
So the pin sheets was one, and also the caliber of staff used for the presiding officers. That's for the parliamentary and the returning officers. Said no, they had to improve the caliber, and it would appear that that is so, because in the current 2020 petition, I don't see in the petition complaints that there were duplicate serial numbers. I don't see that So
yeah, except that in the course of our work on the petition, we came across pink sheets. Pink sheets that did not have the column for indicating the verification, the biometric verification, and that was also a very widespread practice. If you look at CI 127, all right, it has that form, and there's a column there for indicating whether the person who voted, the number of persons who were biometrically verified, and the number of persons who were manually verified. Now, the good thing about, and this is an improvement on 2012, the good thing about the current, biometric machines that were used, the BVDs, the devices, is that the software took you through 7 stages, and it is at if the 7 you cannot go. You fail to go through those 7 stages, then including facial recognition.
Then the manual will come in.
Yes, then the manual kicks in.
Okay.
Then it means that it gave you an opportunity to record the number of persons who were manually verified as against those who were biometrically verified. However, a lot of the pin sheets that were used did not have that column.
Okay. Failed.
It did not have that column for filling.
Right.
So what they did was to use a stamp.
Okay.
And they put the stamp there, and then it is in respect of in the stamp that there's a column for you to fill that.
But you didn't make that an issue because it won't necessarily invalidate the results. Is that the case?
Well, of course, we read and reread.
Exactly. So thanks to precedents.
There are lawsuit decisions,
exactly.
But it may well come up. I don't know what His Excellency and co have under their sleeves, so it may well come up.
Okay.
Can you continue?
Yes. Okay. So we've done duplication of. Okay. Yes. So that also, apart from that, we also got out of the election petition the case of Ishan versus Attorney General, where the Supreme Court then held that the pin sheets and all this should be given to all the parties, the contestants. I know that was very key in 2012. So you remember in 2012, before the EC came out with the results, the MPP had already...
2016, you mean?
Sorry, 2016.
Yeah.
2016. Before the EC came out, the MPP, with the aid of those pin sheets, was able to collate and project themselves as winners. It was, that was very, very, very critical. Because can you imagine, if they didn't have this pin, you remember that popular saying by Lenin or so, that in an election, voters don't decide. It's the counters who decide. So if you didn't have the pin sheets to verify,
to support it, then
they could have just done anything. Okay. Yes, so those are a few of the positives that we got. Apart from we may also mention the education, the transparency it brought about the judicial process and all that. So all in all, it was great. It was great for that.
You talked about the caliber of people the EC got.
That was where I was coming to.
But yes, so that was the presiding officers, I believe. But we do know, even though it's not a subject of the petition currently before the court, we do know during the reportage and everything, or the coverage of the election, we heard of incidents where EC officials were compromised. And it raises issues about the recruitment process of these persons, because we were told that they are not permanent staff, so they are brought in. So that issue too, yes. So
that was the point I want to make. You see, sometimes the mere fact that you see people wearing some identification clothing at the station. Oh, you see official. You create, gives you the impression that these are permanent workers. But these were recruited for the elections. And they, depending upon your level of education, you could be a presiding officer. Others were something this year called COVID ambassadors who were only testing people's, temperatures and things like that. So we should also be mindful of that fact that elections are not held throughout the year. You may have an election maybe for district assemblies, something may come up and then you do a referendum, and then at the end of every 4 years, you're surely going to have election. So you cannot have that staff sitting there doing nothing. So they wait, getting to the end of the time, they bring in people. And can you imagine, look at the manual on elections. You are going to train people within that short period to understand the electoral laws and to apply them on that day. Maybe the training itself took just a day, or maybe 3 days or something. So some of these issues that we have with election officers, I think we should bear in mind that these are not permanent workers of the EC, but people only, recruited. Of course, we have returning officers in the district office or regional offices and the rest. They are permanent workers. So these errors are bound to happen because the people were temporary and they were not properly trained. So the background checks, and if you look at the law on recruitment, they are to be posted in the district for people to go and raise objection about the people. How many people even know where the district office is? What they know is the registration centers. We have open registration. So these, to your police, they go and register here, register here. Right. That's all. If you ask them where the offices are located, they may not even know. So let us be mindful of that issue. That is not that you see as workers who misbehave. And you find that in the law, it is not only people who come to commit offenses who are held liable, but even officials of the EC could also be held liable for having done wrong things. And it is about time maybe we started putting some of them before court. There was one on social media where somebody was alleged to have opened a private police station for children or something, a certain class of people. He was arrested and was begging. You saw it.
I see. There are some crimes.
Oh, yes, they are all there. That's a criminal offense. It should also be.
Soon, and we'll come to you for your concluding remarks. We're just about wrapping up here. So this one is coming in from Nadoli Robert. He says, good morning to you all. It's sad that we are not even talking about the families who lost their loved ones. No one cares about them because we think they caused their own deaths. But what if they did not? We must know that these souls will hunt us back if justice is not served on their behalf. May the souls of all who died in the course of the 2020 elections rest in perfect peace. This one also says, please, good morning TV3, we're enjoying your intellectual conversation, but please, with all due respect, if they could uncover the nose mask when speaking, because, okay. We can't take off we are complying with the COVID protocols, and so we'll try to speak audibly. This one also coming in says, sorry, I'm trying to get these messages. Says, good morning, Abna, and to your panelists. Please remind Mr. Aikotu to speak to facts of the law and not his opinion. Okay, that's Adam in Kumbungu. I think Mr. Aikotu is obviously our member. Saying what he needs to say. Now, this one also says, Abna, you have disappointed me with your disappointed we Ghanaians by your comment saying that we didn't need to have deaths in the 2020 elections. It's hypocrisy. There should be one single debt. I'm not sure what this exactly is, though.
You don't need to.
But anyways, that's your opinion, and you're entitled to that, though. But in wrapping up, I'm trying to get the messages, but it's not that easy. So, in order not to waste any more time, let's just have a conclusion. But before your conclusion, His Excellency, we have a number of requests coming in. People want to know what probably meant when you...
I never used that.
You never did?
It was the NDC people.
It was Akugan.
Okay.
Akugan was the one who said he suffered from...
Okay, and what was that? What did that mean?
Oh, I did explain that day, if you remember, that when some spirit takes over.
Okay. So you are not yourself.
You are not yourself, and you begin to misbehave.
Yes. Okay.
It's only when the thing gets clears off that you realize the enormity.
You'll be told.
Very well. The things that you've done.
Doc, if you could, let us have your concluding remarks on all this moving forward.
Oh, okay. Well, I think I would want to conclude on the Electoral Commission. Yeah, because it's very critical to the survival of our constitutional democracy and the integrity of our electoral processes. I know from 1992, there has always been suspicion of wrongdoing by the opposition. And that's the point that Senior made earlier, that when you are in opposition, you think the EC is in bed with the government. And when, you leave government and going, and vice versa.
Best friends.
Yes. So I think that there is a need for some structural reform. And I've had occasion to mention this, discuss this at a public forum which I presented a paper. You see, the Constitution, the reason why there is enduring suspicion that the EC is always helping the government, all right, is because you have appointments made by the president, all right, and people have the perception that the president appoints only people who are aligned to his party. So Farijan was accused of being NDC, then subsequently, Mrs. Osei, and then now Jean Mensah is also being accused of being MPP and so on. So what I propose was that there is a need for us. The Constitution said that.
Wrap it up.
Yeah, I'll wrap it up. Okay, so
we have let's
have the president, appoint them, but let us nominate representatives of the parties to be the commission.
Okay.
So that the opposition themselves are at the table when decisions are being taken. So they can be in the minority, but the ruling party can have the majority of, members of the. We can have that discussion at another time.
But anything looking at reform is definitely good, so we can interrogate it further. Mr. Kebo, briefly, your concluding remarks.
Okay, so that we'll pray the Supreme Court to have the proceedings televised, live. We want a live telecast so that we can follow. Transparency is the beginning of everything. It helped immensely the last time, so hopefully this time it will. And of course, we'll encourage citizens to be circumspect so that we don't mar the process.
Sure.
All right.
Very well. Thank you for that. His Excellency, you have the last
word. So anybody who is dissatisfied with a declaration of results must go to court. He does not have to go to the street or encourages people to go to the street, and then we have all kinds of things happening. That is my plea.
Very well.
Go to court.
And they have done just that. So we would pray that we do this expeditiously, and we, at the end of the day, the country will be the biggest gainer. This has been the Key Points, and I've had Honorable Dr. Dominic Ayine in the studio, also Mr. Martin Kwebu and His Excellency Ayikwe Otu with us. On Zoom, we had Dr. Hayford here as well. My name is Abna Tebi, and we will be back here same time next week to give you another episode of the show. We do hope you had a good time. See you next week. Bye-bye.